I am the Child Justice Advisor to the Chief Justice of Kenya, and I'm also a lecturer at Kabarak University Law School. And it is actually thanks to the UNODC that has made it possible for me to lend my expertise to the Office of the Chief Justice.
Thank you so much, Juliet. It's a pleasure to be in touch with you today to have a discussion on pages. And you have been involved in that. I understand that you have been involved in the development of the child justice strategy, just like us to have a discussion with promoting justice, especially for young girls, also young boys, also women, the role that women play in that. So, yeah, if I may begin just to ask you a bit about, for instance, the aim of the strategy, like, why, if you can just introduce us to the child justice strategy.
Yeah. Okay. Well, thank you very much for this question. The child justice strategy was developed to respond to a need and a gap that was realized within the judiciary when it comes to access to justice for children, and specifically from the point of view of the judiciary. So if you think about the entire justice system, there are maybe around 8 bodies of the justice system. So you have you have the police, you have the office of the DPP, you have in children rights, you have the children's directorate, you have probation, and then you have the judiciary, you have the lawyers, and from where we sit, you realize that the judiciary does, in one way or another, tend to receive children, or cases of children, or address the issues of children really towards the end. And so there was a need to ask ourselves, what is it that the judiciary can do to actively contribute to access to justice for children? Because the judiciary is known as the custodians of justice. So how do we ensure that we actively and proactively contribute to access to justice for children? And therefore, this is how the child justice strategy came to be. So the child justice strategy is really has a vision, and this vision is also anchored under our constitution. It is anchored under the STAJ blueprint, which is the vision of the judiciary. It is also anchored on Vision 2030 as well. And so the idea of this child justice strategy is to ensure that the judiciary is guided by the principle of the best interest of the child and promote the right to survival and development of all children in Kenya, meaning that it is a very great and an onerous call or task to the judiciary to be at the forefront of ensuring access to justice for children in its task of adjudication, in the judiciary's task of judgment, in its task of as custodians of justice as well. So that is what the strategy is all about. The strategy is also focused on only children. So and it's for that reason it advises on 3 parts or 3 kinds of situations where children find themselves. So this is children who are in conflict with the law, children who are in need of care and protection, and children who accompany their parents or their mothers, their primary caregivers to prison. So that's the main focus area of the strategy. And of course, the judiciary in itself and everything that it could do to ensure the best interest of the child and survival and development of children. Thank you.
Thank you so much, Juliet, for that comprehensive introduction to the strategy. If you don't mind, can also let us know how, given the aims of the strategy and its focus on children, the placement of the judiciary in the protection of children, how does the strategy address the specific needs and challenges faced by women and girls, particularly those who are victims of abuse or in need of care and protection?
Thank you for this question. Really, it's as I said, it's really an honor to be invited to speak on this towards the International Women's Day and on this particular theme, because it shows that we've taken recognition that indeed children, the issue that children face, are highly contributed to the susceptibility of their mothers and of the women around the children to in this world and in this life. So you find that the children who are victims of abuse, also known as children in need of care and protection in the Children Act, are mostly find themselves there because they have faced some kind of neglect. Their mothers or the women in their lives are to a large extent, poor. They are victims of inequalities, be it marginalization or whatever. So the child justice strategy first recognizes this. Actually, if you read through it, you will see the various research that has been done to show this. Recognizes that the girl child is particularly susceptible to being a victim of abuse, sexual abuse, exploitation, child labor, child trafficking. You find that the girl child especially is really the one who suffers these kinds of abuses and violation of their rights. So for this reason, the child justice strategy envisions a judiciary that is not just child friendly, but one that also addresses the trauma that comes with these kinds of violations. So the child justice strategy has proposed particularly in its second outcome, that it is important to have a judiciary that has a trauma-informed court. And so what we are doing towards this end is in two parts. One is advising how that judiciary looks like in structure. So the building itself, or how does it take into consideration the needs of a victim, a child victim. Secondly, it's also the capacity building of the judicial officers themselves and the judiciary staff, so that they can be trauma informed and they can respond to issues of these children from that perspective. Thirdly, is within the strategy itself is advising how to collaborate, the judiciary, how to collaborate with other actors to address all the needs of the child who is a victim of abuse or a child in need of care and protection. Because as we realize that there is the need that has driven the child or has pushed the child to be a victim. So, and the judiciary cannot take care of all that. So what do we do then? We ensure that we collaborate through the something like the court user committee to ensure that the needs of that child are actually addressed. The need, for instance, to education, the need to ensure legal representation, the need to ensure that the child is supported, so they are removed from, for instance, poverty areas and the situations that they find themselves in. So that is what this child justice strategy is advising and is envisioning. And actually, currently, as an advisor, we are talking to the various courts to see how to ensure that we're able to implement this, so that we are not just addressing the issue of, for instance, finding the perpetrator, culpable and putting away the perpetrators of abuse, but also really addressing the needs of this particular child, especially the girl child who finds themselves in these situations. Thank you.
Well, thank you so much for that insightful response, which also spotlighted the capacity building of the court to become trauma informed, and also mentioned the role of the courts in this as a collaborative effort that's been the shifting of the judiciary in the country. For this purpose of protecting children. And perhaps if I may ask if there are ways, you mentioned that there's a conversation that is happening and ensuring that more is done beyond the collaboration, even at a level where the court has this, is now trauma informed and so can therefore provide a trauma-cited response to the providers, for instance. So what measures would you say are in place, or how then is the court being trauma-informed sustained? How is it sustained? What provisions are in the strategy that ensure that the the court being trauma-informed is sustained?
So this is this. I mean, the sustainability of all these efforts really are highly determined by the capacity of the judiciary and the judicial staff, the judicial officers and the judiciary staff. Because even if you have a wonderful building that has directions, for instance, ensuring that the child and the perpetrator do not come into contact. Even if you have a building that has a counseling room, for instance, if the people are not constantly capacity built to address the needs of the victim or the survivor, who's a child or actually a woman, then we will not be able to sustain those kinds of courts. And that is why if you look at the strategy, it is highly recommends training, capacity building, having the judicial officers themselves have access to counseling, so that it is not just them receiving all this cases and listening to all these cases, but it's also to provide for them an avenue to deal and to process everything they're hearing about children. And if you sit through court, especially when children are giving testimony and evidence on cases of, for instance, child sexual abuse or exploitation, child trafficking, it is very, some of that information is actually traumatizing, not just for the child but also for the listener. So providing even access to judicial officers and judicial staff to be able to debrief effectively is also very important, and that is one of the ways in which to sustain this particular initiative. So this is what is actually proposed within the strategy, that it is not just about providing a building, training judicial officers, but it's also ensuring that they also have access to debrief and to be able to deal and process the kind of information that they are receiving, and extending support to also the children. So, for instance, as I said, one of the greatest things that is discussed within the strategy, and we are in the process of implementing it, is collaborating, for instance, with even health practitioners, where we are requesting the government to also support the judiciary to provide some mental health experts, for instance, therapists, counselors, for the children who are coming in contact with the justice system. I hope I've addressed the question.
Yes, thank you so much for that comprehensive response, which also then leaves how it's not only the justice actors or lawyers or judicial officers that only have a role to play. It's interesting how we also see that the health practitioners also have a role to play as safeguarding officers as well in this endeavor to protect children and also provide justice to the children. I understand that the strategy also couples with the Children Act of 2022, to which I would like to seek your insight on how then do you envision the Children Act of 2022 addressing gender disparities within the justice system, especially in regards to ensuring that girls they have access to justice?
So thank you. Access to justice is a right within the Constitution, right? And the Children Act of 2022 enhances that. It makes various provisions for ensuring access to justice. So from the onset, right from the onset of the Children Act in itself, from Section 5 all the way to I think to about 29, it talks about enforcement. It actually talks about safeguards and then talks about enforcement of rights. One of the things I would like to state clearly is that whereas I know in our world we really try to separate the issues of the women and the men, when it comes to children are all vulnerable and susceptible, and they face because of their age, because of their young minds, and because they most of the time have to rely on us as adults to take care of them and address their needs and issues, you find that children are vulnerable and susceptible. So that is first on the onset. I'd just like to make that clear. And for this reason, we say that the Children Act is and will take care and ensures the rights of all children who are actually in Kenya. So that is the first thing I would like to state. But does it highlight issues that, for instance, the girl child will go through? Certainly. Some of the things, for instance, you find that we can call gender disparities. You'll find that the girl child maybe sometimes is more susceptible to things like harmful cultural practice. You'll find that the girl child is susceptible to, as I say, child labor. You'll find them that they are susceptible to sexual violence and all these things. What the Children Act has therefore asked and is requiring of the state, from the judiciary and any other person who has an obligation within the Children Act, is required to ensure that we take care of children and take into cognizance the gender. So if, for instance, we have a child holding facility, the child holding facility must ensure that we have set up protection measures for girls, we have put up protection measures for boys. If we, as I said, in the institutions, the boys and the girls have to be separate. The women and also the girls, for instance, even in a police station setup, they have to be separated. Because we cannot assume that just because they're women and girls, they can all be put together. The Children Act requires that wherever we are putting children in any institution, the police, the cells, the rehabilitation centers, the remand homes, all those must take into consideration the age, and they have to take into consideration the gender of the children. So it's not just about girls, but it's also girls, boys, and the intersex child as well. So we have to separate those children when it comes to the institutions. And then, of course, as I implied earlier, there are those issues that the girl child suffers from. So like, female genital mutilation. Can you hear me now?
Yes, I can hear you clearly.
Okay, yeah.
My apologies, I dropped off from the call.
Oh, okay.
I'm so sorry, but you were talking about the issues that the girl child faces, especially trying to mention matters of FGM and virginity testing.
Okay.
Yeah, I'm sorry I dropped off. I hope this didn't interfere with your stream of thought.
Yeah, I mean, I think I was, I think I was actually done, when you were, let's see. I think I was actually just concluding on that, because I was saying that the Children Act does, addresses the issues of, the girl child, and rather the gendering aspect of, children through, addressing so specific, offenses that could be against girls. That's number one. And then number two is by gendering, what's the word? directing that any institutions that have set up systems or institutions or places where children can be held to ensure that they desegregate the children by gender. And I say that it's not just gender in terms of girls and boys, but it is girls, boys, and the intersex children. So if the police were, for instance, to set up a child protection unit, they'd have to take into consideration these three genders. If the Directorate of Children's Services is to set up a holding place for children, for instance, the remand homes and the rehabilitation centers, they also have to take care of these three genders, the girls, the boys, and the intersex. And also within the police stations, if they have a cell for children, it cannot be women and girls together. It has to be separate girls and boys as well. And also for instance, if the judiciary has a holding place, then it has to take into consideration the three genders. So that is the point that I was making. That is how the Children Act has recognized any gender disparities that could lead to hampering of access to justice for the child. But essentially, the Children Act mandates all the entire government and the state and its state organs to ensure access to justice for all children. Thank you.
Thank you so much, Juliet, for that insightful response and connection. So, thank you so much for highlighting the efforts of the judiciary and the many actors, the health practitioners, justice committee, everybody else, including the public, towards the protection of children, and not only women, not only girls, but also boys and intersex and the inter. So, if I may ask, if you have any knowledge how the justice system, for instance, is advocating.
Sorry, repeat that question.
Sorry, I'm asking if you may have insights, can give us any insight on how the justice system advocates for financing towards improving access to justice for children.
Yeah, absolutely. So, the financing is one of the biggest, I think, what's the word? It's one of the biggest hindrances towards access to justice. If you look at the budgetary provisions in the state, you realize that the finances and the resources, rather, that are put towards improving access to justice are not as much as in other programs. Yeah. And so I find that this is one of the biggest challenges that we are facing as a country, and I don't know, maybe as a society, that we have not yet been able to properly quantify access to justice. Maybe it's a question of properly quantifying it, but also just addressing the need of providing adequate budgets towards access to justice for children. In fact, let me not even just say for girls, but actually for children. However, what we are calling for, or what even within the strategies, for instance, that we have developed through, for STARGE, there is a STARGE blueprint, which is the vision of the judiciary. And this particular strategy, the child justice strategy, is to create opportunities for collaboration or collaborative efforts through all the justice actors and NGOs that are dealing with access to justice for girls or for children or for women, to advocate through Parliament and demand for the required resource allocation for children. It is this is one of the greatest, I think, needs that we must address together collaboratively, as I said. And I think this is a good place to bring in the National Council on Administration of Justice, that is the NCAJ, so that because the NCAJ brings together all the justice actors, I think it does also provide an opportunity for the justice actors and their supporters, that is the NGOs and INGOs, to speak together as a group and really demand for adequate financing towards improving access to justice for girls. That is one. That is from like the general perspective. But more specific is also, for instance, awarding of damages when it comes to cases in court. I think this is where really one of the greatest solutions, lies, is where a child has been violated and abused, whether it is a girl or a boy child, but because we're talking about girls, I'll talk from that perspective. So where you find there is a case of maybe child trafficking or child sexual abuse, then the Victim Protection Act allows for the court to provide some form of damages to the child, to the victim. So using the Victim Protection Act, using the Children Act, and using the other law, for instance, that defines the offense against the child or the girl child, the court is at liberty to actually award some damages to that child. And I think this is one of the ways to start financing improving access to justice, because, as you've said, the children or the women are finding themselves in these situations because of vulnerabilities and inequalities, poverty being one of them. So if you award damages to take care of the medical aspects, to take care of maybe educational aspects for the victim, then we remove the child from the situation that pushed them into being victims of abuse in the first place, and setting them up in a different kind of space. So I think this is one of them of a more particular role that the judiciary has that can actually work towards improving access to justice for girls. Other than that, the National Council on Administration of Justice would be a better place to be used to advocate. And third is, as I said, that you asked about the justice system. So the third one is my other capacity as an advocate, using, for instance, strategic litigation, cases to court, to bring them to court, to mandate the executive, for instance, and parliament to allocate some sort of funding to ensure access to justice for girls. Thank you.
Thank you so much, Juliet, for that insightful response and feedback on the investing towards financing access to justice for girls. It's really helpful to just bring in to see then how that injection of support then furthers the mission and the aims of protecting children, in particular protecting girls. And so, besides this child justice strategy, would you say that there are any other initiatives within the justice system that amplify the voice of girls in this regard?
Yes, certainly. There are so many other initiatives. So I can say first of all that the voices of girls, and especially children, is enhanced through the Children Act, and because we have one of the principles, the guiding principles in child rights is called child participation, and the Directorate of Children's Services, the NGOs, the judiciary, and the DPP, for instance, are hard at work to establish systems so that children can have a space for them to speak up and speak out on their own issues. So there are various avenues that have been established to give the child this access to these platforms to be able to speak. One is the Kenya Children Assembly, that is an assembly for children across the country. The other one is the other ones are, I forget the other one, for county governments, actually, for devolution, yes. Devolution Children Conference, sorry. So Devolution Children Conference is another avenue that children have to actually speak. Within the NCAJ, we have several committees. One of the committees that I sit in is the NCAJ Standing Committee on Administration and Access to Justice for Children. This NCAJ committee has established a space for children to speak out and for university students to also speak out. And these are called Wakili wa Watoto. So we have established our Wakili wa Watoto Club, which helps the child which creates a platform rather for college students, high school students as well, to have an avenue for them to speak out directly to the committee. The NCAJ Standing Committee on Access to Justice and Administration of Children, is chaired by Justice Teresia Madeka. And so using the Wakili wa Watoto clubs, which is for university students, and Mtoto na Sheria, which is for the primary school and the high school, the children can speak directly to NCAJ, so that they can be able to, to highlight their own issues and to share with us their own plight, and also actually actively contribute to our work and tell us what it is that we are looking, where we are looking, what we are looking for, what are the effective measures to address the issues that the children are going through. And one of the greatest successes, I'll say, when it comes to amplifying the voices of children is actually the Children Act. The Children Act 2022 is literally a voice of the child. All through it, when you read it, I think it is important for the world to know this, that the children contributed effectively to the development of that Children Act. There are particular sections and sentences that are literally borrowed from the mouths of children, including raising the age of criminal culpability, bringing access to justice for children who has lost their parents and have issues when it comes to inheritance, the question of social security for children as well. All this were actually raised by children. So the Children Act is one of the best examples we have for child participation and amplification of voices of children to address their own issues. So those are the various initiatives within the justice system that have allowed or that amplify the voices of children.
Thank you so much, Juliet. And perhaps at this juncture, if I may just request for if you may have any parting shots regarding International Women's Day at large and children at large, or any call to action for the public or any other person out there that may be enthusiastic about, protecting children, ensuring children are safe. If you may have any final remarks in that regard.
I have, thank you, Steve, and thank you for this opportunity again to just contribute to the messaging for, in the International Women's Day. Truly speaking, I go back to what I said about financing. We have to put our money where our mouth is, and we have to. So my call to action, one, is to the government of Kenya. We must put money and resource towards access to justice for children and for girls. Otherwise, we will never be able to address the violation that these girls are facing every single day. That is number one. Number two, because it's also about investing and accelerating progress, I think it is easier to prevent than it is to respond. And because we know that the reason as to why women and girls are susceptible to violence is because of inequalities, then I think as a state, it behooves us to ensure that we address the issues of gender inequalities through prevention. So what am I talking about? Ensuring that the girl child has access to education without any reservation. That means that even the girl deep in Turkana has access to education. The girl who is in Baragoi has access to education. And that the woman has access to water, has access to land, has access to food. Because if those two are actually addressed, then we start working towards prevention mechanisms of violence against children and against women and against adult child.